Good morning, good afternoon, and good evening. I'm Daun, a research fellow at the CIL. We are very pleased to welcome speakers and audience to the second webinar of Maritime Autonomous Surface Ships and UNCLOS. Today, we will discuss MASS and flag states, focusing on the relationship between UNCLOS and the IMO Conventions. I have a few housekeeping notes to make before we begin today's webinar. First, the webinar will be recorded only for internal purposes. Second, if you have any questions or comments during the webinar, please use the Q&A function in the menu bar that is located at the bottom of your screen. Without further ado, I would like to introduce a moderator and 4 panelists. The moderator of today's webinar is Prof. Beckman. He is an emeritus professor at NUS Law School and the head of the Ocean Law and Policy Program at the CIL. It is also my great pleasure to introduce 4 excellent panelists. Our first panelist is Professor Aldo Chico, who is the Canada Research Chair in the Maritime Law Policy at the Dalhousie University in Canada. The second panelist is Captain Ashley Loach, who is the CIL Visiting Senior Principal Research Fellow and the former Office of the Legal Advisor in the US. And third panelist is Dr. Henrik Ringbaum, who is a part-time professor at the Scandinavian Institute of Maritime Law at the University of Oslo in Norway. And our final member of the panel is Dr. YURI van Lochem, who is the senior lecturer at the Institute of International Shipping and Trade Law at Swansea University in the UK. Now, Prof. Beckman will give a brief overview of the discussion on MASS at the IMO, and then he will lead an interesting discussion. Prof, you have a floor.
Okay. Can you see my slides okay? Are they in the right?
Yes, Prof.
Okay. All right. Good morning, good afternoon, good evening, everyone. Last time we had a very informal discussion. This time we decided so that we think that it'll help the audience that are not experts in the area if I first give an overview of some of the issues by way of PowerPoint, and then we'll open it up for discussion and comments from our panel members. So it's going to talk first about IMO and UNCLOS generally, then summarize the current state of the IMO regulatory scoping exercise on MASS. Part 3, in terms of selected provisions, I've anticipated some of the provisions that our panel members may want to discuss. And for the benefit of the audience, when those provisions are being considered, I will put the text on the screen so that it'll be easier to follow the discussion. With respect to IMO and UNCLOS, I'll quickly run through this. The 1982 Convention on the Law of the Sea, negotiated over 9 years, beginning in 1973. It's a framework convention that is almost impossible to amend. Now, it was drafted in the 1970s when the IMO was adopting new conventions, including CORAG, SOLAS, MARPOL, and STCW. The IMO instruments are universally accepted and are continually being updated and amended through the tacit acceptance procedures of the IMO. UNCLOS contains general provisions on obligations of states that are intended to incorporate by reference the latest IMO conventions. Now, examples of phrases are so-called rules of reference in UNCLOS. No standardization. The drafting committee didn't attempt to standardize it, but they talk about generally accepted international rules are standards, generally accepted international regulations, generally accepted rules, international regulations on prevention of collisions, Those same with respect to safety at sea and also with respect to prevention, reduction, and control of pollution from ships. In practice, that means when flag states are looking at their obligations, they're looking at the technical rules in the IMO conventions, whether it be the Maritime Safety Convention or others. Now, the issue raised by MASS is whether the UNCLOS provisions without phrases incorporating the IMO conventions by reference can also be interpreted in light of the IMO conventions and regulations. In other words, can the IMO regulations provide some content by which the international community, particularly flag states, would interpret the general provisions in UNCLOS? I refer everybody to a document which I believe has not been updated since 2014, the study by the IMO Secretariat on the implications of the UNCLOS for the IMO. Document examines the relationship between UNCLOS and the IMO instruments regulating shipping, and I give you one quotation from it. At page 104, in addition to the new or modified functions and responsibilities directly or indirectly imposed on the IMO by UNCLOS, may be necessary to consider what other possible roles, if any, may legitimately played by the IMO in connection with the implementation of the provisions of the convention that deal with matters within the field of competence of the IMO, particularly the provision whose interpretation or application may be assisted by work within the IMO, because it's generally acknowledged that the IMO is the UN body with competence over merchant shipping. So with that background, I'll quickly look at the current state of IMO regulatory scoping exercises on MASS. A reminder, we could discuss this last week, but I think those that are again not familiar, it might help to see it on the screen. There's 4 degrees of autonomy that has been identified by the IMO groups. The degree 1 is a crewed ship with automated processes and decision support. Degree 2 is a remotely controlled ship with seafarers on board. Degree 3 is remotely controlled ship without any seafarers on board, and degree 4 is a fully autonomous ship. Now, it may be many years before we get to degree 4, but the consensus that during our last webinars, we should be focusing particularly on degrees 3 and 4, although I would argue some issues would arise also with respect to degree 2. Next, looking at what the Maritime Safety Committee has done, its report of 25 May 2021 on its 103rd session. Well, there was wide support for the establishment of a joint MSC Legal FOW working group, that's a legal committee and the facilitation committee, to coordinate MASS-related regulatory work. The committee believed it would be premature to do this at this time. Recognize the committees had not yet completed the regulatory scoping exercise for instruments under their purview, and that any future work on MASS undertaken by a joint working group would require identifying common potential gaps and themes, as well as priority for future work from all committees. In this connection, committee recalled establishing a joint working group would require a new output agreed and approved by the 3 committees. MSC circular, the outcome of the scoping exercise for MASS document of 3 June, talked about 3 high priority areas, common gaps and themes, meeting of the terms master, crew, and responsible person, difficulties with respect to the remote control station or center, and the remote operator as a seafarer. Development of a new MASS instrument was discussed. Common gaps and themes cut across several IMO instruments. The MASS instrument may be considered and made mandatory by means of an amending an existing IMO convention such as SOLAS. This is exactly what happened with the International Ship and Port Security Code. If you adopt that as a amendment to major convention like SOLAS, it then becomes binding on all members under the tacit acceptance procedure. Development of new mass instruments should preferably be developed by following a goals-based approach. This has been the view of the Maritime Safety Committee. The Legal Committee met in July 2021, noted that both the MSC and Legal had concluded that the role and responsibilities of the master and remote operator are high priority issues, must be addressed as a foundation for any future work. The scoping exercise of the Legal Committee concluded that consideration of these issues would best be addressed jointly between the committees, so that both technical and legal aspects and questions of liability are taken into account, while keeping in mind the different purposes and functions of the conventions under the purview of the Legal Committee and those under the purview of the Maritime Safety Committee. They also noted that the conventions not under the auspices of the IMO, such as UNCLOS and the Maritime Labor Convention of 2006, may need to be considered in the IMO's future work on MASS, particularly if IMO developed an instrument regulating MASS operations. So you have now the Legal Committee mentioning that perhaps conventions outside the IMO framework should be considered in developing a new convention. Maritime Safety Committee report of October. Committee took the following decisions. They requested the chair to prepare, together with the secretariat in consultation with the submitters of proposals and commenting documents, so on, a roadmap including the scope, steps, and timeliness, as well as the coordination of work with other IMO bodies, taking into account the documents, etc., for an outcome on the scoping exercise with detailed consideration at the next session of the Maritime Safety Committee in number 105. The Maritime Safety Committee report on this 104th session took the following decisions. Biannual agenda of the committee for a provisional agenda for a new output, the development of a goal-based instrument for maritime autonomous surface ships, the target completion of 2025, taking into account that the title of the output may be adjusted based on the review of the roadmap. Agreed that the ultimate goal would be the preparation of a mandatory instrument to address MASS operations. Now, the Facilitation Committee had an intersessional working group also examining MASS, November 2021. Gaps and themes that are common across the Maritime Safety Committee, Legal Committee, and Facilitation Committee instruments. They found, again, the common theme here of all three committees: the role and responsibility of the master and crew, role and responsibility of any remote operator, definitions and terminology of MASS, and then issue with respect to certificates and other documents that the ships would be required to submit. The intersessional working group of the Facilitation Committee of 3 November, they concluded conventions not under the auspices of the IMO. They noted that the Legal Committee concluded that conventions not under the auspices of the IMO, such as UNCLOS, would need to be considered in the IMO's future work on MASS. They would be particularly relevant if the IMO developed an instrument to regulate MASS operations, which of course is what the intent is. As far as amending the Facilitation Convention, they said, in contrast to the results of the Maritime Safety Committee, the development of instrument was identified only in relation to the more overarching issues, which is, again, those same issues that we've mentioned. These are the issues that the FAO Convention shares with the other IMO instruments, and they should be addressed in liaison with the other committees. Common gaps and themes. Both Maritime Safety Committee and Legal have concluded the role and responsibilities of the master and remote operator, high priority issues. Any discussion of the roles and responsibility of the new actors emerged from the introduction of MASS would rely on clear definition of the actors and their responsibilities. Coordination among IMO instruments should be reached at the future use of terminology before beginning considerations on amending the convention or developing a new instrument to accommodate MASS. So that's where we are. I think with that in mind, I would open it up to comments from our speakers. If we want to go in the same order, or whoever wants to come in, come in. At this point, I'd like to simply referee. I guess the underlying issue is, should the IMO committees, or if they form a committee of a working group of the three committees, the fundamental issue is whether they should be looking at the IMO, the UNCLOS provisions in drafting that document that they're preparing to perhaps fill gaps or add details that the UNCLOS does not provide. Go ahead, Ash.
I've got a couple of additional sort of facts I think that the participants and the viewers need to bear in mind. And the first is, you've referenced MSC 105, but you should also, everybody should know that that doesn't happen until April of 2022. So it's in the future. And MEPC meets actually next week in London. So it'll be interesting to see what they come up with. And for further information, Leg 108, which is the next meeting of the legal committee, doesn't occur until March of 2022. So we've got committees that are laid on to do new work, but I think they'll be taking those up coming up. But more interestingly to me is the fact that the biennial assembly meets in December, and although there are no documents yet on this particular issue, the unique things about the assembly is that there's no requirement for your documents to be made early. So it'll be interesting to see what, if anything, the assembly deals with on these issues, because it could have a major impact, or it could confirm what's going on. But I would hope at least that the assembly addresses these issues so that it's clear across the whole of the IMO where they are and where they should be going.
Okay, thanks, Ash. Can I have a follow-up question? Does anybody have any information that I do not have as to why the MEPC, which is obviously one of the major IMO committees, has not yet, as far as I know, done any work on MASS? Does any of our panel members have any information on that?
I think that the answer is simply that they have been so busy with other things that they haven't really had the time to look at it. They have been talking about it, but also I think part of the answer to that is that many of the conventions under their purview are not necessarily the ones that are most crucial in this respect, and maybe that's a sort of implied reason for it as well. But the only sort of other reason is really this lack of time. They, of course, have their hands full with greenhouse gases and everything else.
Okay, very good. Anybody else like to comment? Aldo, you want to come in? Any issues that were?
Yeah, I was thinking as I was listening to my colleagues about I was thinking about the role of the legal committee, because the legal committee in the IMO Convention itself has a pretty strong mandate to undertake the kind of legal interpretation.
Wait, although you're a bit soft, could you try to speak up a little bit? Maybe it's my old ears, but
Your ears and mine as well, Bob. Yes, I was saying that the legal committee here, indeed, by the IMO Convention itself, is granted very significant power to consider any legal matters within the scope of the organization. And if you look at interpretation of the mandate of the organization itself, it would give it a very substantial mandate, I should say. And indeed, in Article 33, in addition to that, the IMO Convention states that the legal committee shall take all necessary steps to perform any duties assigned to it by the IMO Convention or by the Assembly or the Council within the scope of the article and so on. So it's, on the one hand, I think it's clear that the legal committee has a very broad mandate to interpret, specifically within the framework of the IMO Convention, so primarily with respect to the instruments of the IMO. But the reference to any legal matter suggests that maybe there might be some residual interpretative power, and it might relate, for instance, to the scope of the GIRAS, which the IMO, as the competent international organization under UNCLOS, would be expected to develop.
So would you say the legal committee would have the mandate? If not, would it be their responsibility, if not mandate, to review UNCLOS in light of MASS?
No, this is interesting because if you look at the history of the work of the legal committee, and perhaps the other committees, there have been a number of instances where questions have been raised about the mandate of the IMO itself. And indeed, the opening statement is that the IMO can only interpret its own instruments. But having said that, if you think in terms of the role of the IMO in developing GIRAS, there is implicitly, I would argue, some sort of a role for the IMO in understanding its mandate to develop those GIRAS, which indeed then are reflected in the various instruments, codes, and so on. So I'll give you a couple of examples where there seem to have been two different approaches on this. The first is the, you may recall, the Western European PSSA proposal. And there was an issue with respect to the size, the consolidation almost of 6 exclusive economic zones and the impacts this would have had on innocent passage as well as freedom of navigation. You may recall the original proposed measures and eventually boiled down to just one, the reporting measure. And the legal committee indeed was quite divided, and there was a substantial group of states and consultative members with or rather organizations with consultative status that basically convinced the committee that it was important to seek the opinion of the Division for Ocean Affairs and the Law of the Sea. And indeed, they did get an opinion. So there have been instances here when there was a specific question related to the scope of application of UNCLOS itself that required essentially an opinion from the WALOS. But not all issues that concern the convention that arise at the IMO necessarily are so very clear in terms of the need to get the external opinion. I'll give you an example here where the IMO may not have had as much of an issue as it had with the Western European PSSA. And this concerns the Casualty Investigation Code. The Casualty Investigation Code concerns the framework for the conduct of investigations by flag states, by other states as well, when there is a maritime casualty. And Chapter 7 of that code actually concludes with some very interesting text. So here is a code that develops a framework to essentially flesh out the obligation of states to conduct casualty investigations under Article 94 of UNCLOS, and essentially saying, look, by fully participating in a maritime safety investigation conducted by another substantially interested states, which could be, for instance, even a coastal state, the flag state shall be considered to fulfill its obligations under this code SOLAS Regulation 121 and Article 94, Section 7, subsection 7 of UNCLOS. So there is an example of, on the one hand, you have the legal committee seeking a Dovelos opinion on a matter concerning the interpretation of the convention, and on another, developing essentially a code and provisions providing guidance for states to conduct casualty investigations, where they were specifically interpreting a provision and saying so in the code itself.
Would you distinguish the two by saying the casualty investigation is clearly more within the purview of the IMO? And I would argue that a lot of the issues with respect to MASS are exactly the same. I'm myself as the so-called law of the sea expert, I'm not sure you want law of the sea experts coming in to interpret the provisions of UNCLOS as respect to the regulation of shipping. To me, you want your regulation of shipping experts taking the lead on this, not necessarily UNCLOS people. That would be my view. I'm not sure others agree. Ash, you have a view on that? You got to unmute. You're still muted.
I know. There we go.
There you go.
I'm clear now. I have a couple of thoughts that are related to what you've been talking about. And before I get to that, I wanted to go back to one point you had on a slide, which talks about the difficulty in amending the Law of the Sea Convention, which on its face is actually true. It's created in such a way that it can internally, if you will, be amended. But in fact, the convention has been actually amended twice, as some of you may know, through what do we call them? Implementing arrangements, which have been done both with regard to fishing and otherwise. So there is a mechanism in due course that if states feel that the LOS convention needs to be in one way or another adjusted to take into account the developments of MASS and indeed the developments of regulations within the IMO, there is a mechanism for doing that. It's premature to do anything more than just indicate that possibility exists. But it would ultimately be a function of the state's parties, and in that regard, I want to bring everybody's attention this wonderful book that CIL put out, where Sachin Nandan, who was involved in both of those implementing agreements and some others, sets forth his thoughts and experiences to how that occurred, and it's really worth reading because it gives you a great deal of insight about how the process works.
Okay, any comments from others on this before I come in? Henrik.
Yes, thank you. I share your concern that a few persons specialized in the law of the sea would be sort of tasked to provide an interpretation of its applicability with respect to the MASS, and for several reasons. But maybe the main one is, of course, the nature of the Law of the Sea Convention and its character as a framework convention, which in a way delegates the rule-making powers to one single organization in the field of shipping, and that is the IMO, and gives its relatively free hands to develop the rules as it sees fit. I think that has to be the starting point, because I mean that was the whole design of the constitutional system for the ocean, and that has worked fine, and small adjustments have been made over time, also in law of the sea matters by the IMO in the field of ships routing or other small issues throughout the history, and it has worked fine. Just shifting balances a little bit. But also, I think it's important to bear in mind that when it comes to MASS, these references to these international rules, the GAIRAs, they serve different purposes in different places of the Law of the Sea Convention. If we talk about the flag state rules, Article 94, they are there to provide a minimum standard for the flag state to operate. There is nothing in the Law of the Sea Convention that prevents a flag state from implementing higher standards for its own ships. By contrast, when it comes to coastal states, those same references normally work as maximum limitations on how far the coastal state can regulate, and they cannot go beyond that. But I think, so in the case of MASS, the problem is essentially that we have very little standards at all. Some of the rules that currently exist, the generally accepted rules and standards, would in fact be have to be violated in the case of MASS. For example, the STCW's rule on so in that, those kind of situations need to be amended at the IMO for flag states to be able to comply with the rules of Article 94. But for the question whether the flag state can go further, it's not really an UNCLOS problem at all. It's a bit like in SOLAS, you have special rules for ships that have a temporarily unmanned machinery spaces. It's an option, and the flag state may choose to use that option or not. It's not really I mean, it's not a minimum requirement in the sense that would have to be complied with. So I think that is also very important to bear in mind. But the consequences of all this is that IMO is of critical importance in legalizing MASS, because without any rules on MASS, it will be very difficult for a single state to do it. But then, in my view, it is clear that if IMO proceeds to legalize MASS and say that this is okay, provided you do A, B, and C, and D, and E, I cannot see that the UNCLOS would really provide any substantial limits. Also, not in the wording of the text, but certainly not in the whole sort of character of the framework convention, which is precisely to allow development to take place without having to amend the constitutional regime.
Are you suggesting then that the IMO can simply not consider UNCLOS provisions and do its scoping exercise purely by looking at IMO instruments?
Well, as a starting point, I would say that would be the first thing to do at least. It would also be very difficult to assess the impact of UNCLOS before you know what sort of rules are needed, are in the making. So I think IMO should feel quite free, in my view, to develop whatever rules it feels it is needed, and then whatever issues to UNCLOS may arise in the process. I mean, I don't think there is a single authority in the UN Secretariat or I mean, it would be very awkward, not least in light of this difficulty of amending the Law of the Sea Convention, if somebody is given the authority to interpret an old provision which was drafted with very, very different things in mind than autonomous ships, would somehow be able to rule out a development if the IMO considers that development is desirable. It cannot be in the spirit of the Law of the Sea Convention to have that sort of outcome. That would be my position.
Right. I guess the question, though, is then should IMO go ahead and simply review its own conventions and regulations and not consider the provisions in UNCLOS, which obviously the legal committee, some of the people in the legal committee believe they should be looking at. Yuri, you have any views on this one?
Yes, I do, and I tend to disagree with Henrik quite extensively on this point, because in my view, it seems a bit a topsy-turvy world if we're going to say, okay, the IMO conventions form the starting point rather than the Law of the Sea Convention. In my view, the Law of the Sea Convention should be the starting point. And I think there's a very clear need to analyze the degree to which the IMO can actually tackle all these issues. Because I think in certain respects, where there is a reference to rules of reference, essentially, then it's much easier. But I think in some of these provisions, there's no such mention, which I would say very much underscores the need for addressing the Law of the Sea Convention seriously. And I think also what Ash mentioned about, of course, amendment of the Law of the Sea Convention as such is very difficult, but there are other alternatives. But my view is very much we need to start with the Law of the Sea Convention and see particularly to what extent the IMO is able to tackle all these issues. And I think, to be honest, that some of them can't be tackled by the IMO because they would be acting ultra vires essentially, because if you have rules of reference, fine. But I don't think that we can simply ignore the existence of the Law of the Sea Convention and take a very pragmatic view. Of course, when the Law of the Sea Convention being negotiated, and I do agree with it being a framework convention, but we still have it. I mean, I always think the argument of if we don't facilitate these technological developments, the Law of the Sea Convention would become irrelevant, out of date. I think is always very overblown because the Law of the Sea Convention is able to accommodate technology quite generally. I mean, of course, if you would accept theoretically that are not ships or vessels, but that they are vehicles, they can still operate in the EEZ at high seas. Of course, you have the issue with the territorial sea, but I'm always a bit, I don't know, I'm always a bit, when they hear about, okay, we need to set aside the Law of the Sea Convention, focus on what the IMO is doing. My first and foremost question would be, can the IMO actually address all these issues? And my preliminary answer, and I think we're going to look at some of the provisions in a minute, would have to be no.
Aldo or Ash, any comments in reply to, do you disagree with both of them or?
Well, I suppose we haven't really had anything quite like MASS yet at the IMO. It seems to me that we must not forget that the IMO's mandate comes from three legal sources. The IMO Convention itself, 1948 Convention, which is very clear in providing the machinery for cooperation on all things related to safety, environment, facilitation of trade, and so on, okay? The second is the IMO Conventions, so adopted through diplomatic processes and so on, which designate the IMO as a secretariat plus the system for the maintenance of the convention, tacit acceptance, and so on. So there's a very clear source, a growing source, if you want, for the legal mandate. And the third is the UNCLOS. Let's not forget that UNCLOS provides part of the mandate of the IMO through the GAIRAs and the rules of reference. So the IMO has a responsibility when it's addressing a new regulatory subject matter to use all of its mandate to be able to address this holistically, coherently. Now, what the IMO has to be careful about, though, is that the UNCLOS is not an IMO convention. And there is an undefined line, perhaps, that might or might not be crossed. And as long as one is within the IMO is dealing with technical and operational matters, standards, and so on, that could be generally characterized as GAIRAs, the IMO should not be inhibited from interpreting its mandate under UNCLOS. But if the interpretation of that mandate takes it into some fundamental questions concerning the freedom of navigation, international navigation rights, and even the rights and powers of coastal states, that is a line that the IMO should not be crossing and should be seeking the advice of the whaler. So it seems to me that one needs here a more nuanced approach to what the role of the IMO should be. Which, returning to your question, Bob, should the IMO actually start looking at UNCLOS? I would say yes, but to the extent that the technical and operational aspects of MASS may raise questions of interpretation and application.
Okay, very good. Okay, Ash.
It seems to me that the discussions at the IMO generally are adverse to considering LOS, but I think they're evolving in recognizing that they have to do that. My guess is that to ensure that the relevant committees all take on the task the same way, that it would be very useful if Assembly in December could address that and provide some clarity of direction to the committees, I think that would very much facilitate the resolution of the questions that we've just been talking about in terms of the IMO looking at the LOS convention.
Okay, with that, I think maybe I could, is my share screen still on?
No,
It's not on. Let me,
looking at you.
are you seeing now
There we
full
go.
screen? Sorry? Full screen or part screen?
It's part screen now.
Uh,
There you go.
okay. Let's look at some selected UNCLOS provisions to see. One, nationality of ships.
Prof, before talking about provisions of UNCLOS, can we check some Q&A because there are some questions relevant to the current discussion?
Okay, good. Whose do you want me to read? Kenneth? Okay, I see one. IMO has identified 4 degrees of ship autonomy. Recent autonomous development seems to be leaning towards autonomous navigation as the first step. What is your view if a vessel is able to perform autonomous navigation with no crew and is able to operate the system of the ship, is able to make decisions to determine actions by itself, but not able to monitor system health? Do you still consider it as a degree 4 vessel? What sort of steps and consideration should be taken to consider a holistic manner? I myself am not clear what he means by system health. Does somebody have a better understanding of this question than me?
Maybe I could just briefly comment on that. I think it's a very relevant point that if and when IMO starts developing technical rules for MASS, it is very important to consider, in particular if we're talking about degrees 3 and 4 autonomy, about how the system also is able to check itself, basically. That this is one of the current legal voids in any of the IMO instrument, obviously, that needs to be addressed somehow. There needs to be certain criteria for verifying that the system is up to standards, not only when the MASS is put into operation, but continuously that it's functioning. I think this is what the question is after, and I would totally agree that this would form a very relevant part of the very large number of issues which need to be regulated from scratch, because in the existing IMO rules, which have been subject to now the scoping exercise, of course we don't have anything like this because we haven't had the need for it. But if we are going to accept ships in the future which are fully dependent on systems, then it needs to be the requirements for the system and its ability to verify its own functionality as well.
Okay, anybody else want to comment on that one?
Yes, Bob.
Yeah, go ahead, Ash.
Go ahead.
I've had some experience on the defense sector, particularly on the U.S. Navy side, in terms of they're developing autonomous ships. And it strikes me that although those are not the subject of what the IMO is doing, what the defense industry has done with regard to these ships probably has some lessons that hopefully the relevant state parties can bring to the attention of the IMO and its work.
Okay.
If I may add, Bob, I
go ahead.
Agree with Henrik's statement that this is an important question because it does raise the need to rethink what would be comprehended by the system of periodic surveys of ships from time to time to ensure that they're conforming to SOLAS and other standards to ensure that they continue to be seaworthy. So if there are, for instance, any issues within the system, in particular with the computing, with the algorithmic side, and so on, then we will probably need some specificity in the IMO guidelines in terms of what periodic surveys ought to include.
Okay, good. The second question is, beyond IMO, other international bodies have some roles and responsibilities. IALA, IHO, ITU, ISO, IEC, just to name a few. How you see the coordination and gap analysis and a better understanding of the future ecosystem under development? Do you see any interagency coordination body emerging? My quick view on that, if we look at COVID, it would be perhaps coordination among the relevant agencies, whether it be WHO, ILO, and IMO, and ICAO, but I think we'd have to look at it issue by issue. But does anybody have any other, in terms of the autonomous ships, how many other agencies? People have raised, besides UNCLOS, the Maritime Labor Convention of 206, which is the ILO. Should the MASS scoping exercise also look at the implications of the Maritime Labor Convention? And then are there others?
Bob, I think the question about the role of other organizations is important here. And IMO itself recognizes that. In fact, the IMO has a system of bilateral agreements with many of these organizations to coordinate mandates when there's an overlap. And just to give you an example, there have been even instances of joint committees. And for instance, with ITU, the IMO did establish a joint committee on radio communications, because it makes sense that you have here two regulatory bodies, one concerning, of course, communications, access to wavelengths and so on, and the other, of course, ships that use these communication services. So what I would expect is that MASS will be an additional consideration for this work that requires cooperation and joint tasking.
Okay, any other comments? Otherwise, we have a couple other questions. My view is that IMO MASS exercise inter alia ensure that the provisions developed by the IMO are not in conflict with UNCLOS, but substantiate the latter's provisions. In addition, the interpretation of the provision of an instrument is the prerogative of the parties to the instrument. Any comments? And then the same person asks a second question: can the interpretation of a treaty evolve with the passage of time and related developments? Anyone want to respond?
Well, I could respond first because I would fully subscribe to this point of view, and I don't really see. I would agree with Yuri's position if there was a clear provision in the Law of the Sea Convention anywhere which in reality would rule out autonomous ships or autonomous ships, unmanned ships but really I don't think there is such a provision, and I think to the extent there are references to crews and captains, etc., they are relative, and they are referring to rules to be adopted elsewhere. So I think I don't think there is a conflict between the two, and I would agree that this is really how that it's well described in the question, really, how this interaction between the IMO rules and UNCLOS works in this respect. Now the second question, can you repeat that? I forgot.
Second question was, can interpretation of a treaty evolve with the passage of time and related developments?
Absolutely, it can, and of course, it also in this context, it's quite relevant also that I think in interpreting the treaties, the IMO treaties, of course, but also the more generic question of what should be allowed and what should not be. The main community that should be doing that interpretation should be the international maritime community, and that of course is the parties of the IMO. I don't see a better place for actually taking up this question.
Does anybody see any other international organization that should be involved to the review of MASS? Isn't communications a big issue with respect to a MASS vessel? MASS vessel, I would assume, must be able to communicate with the flag state, with the remote operators if they're in a third country, and also with any coastal state or port state that it may be nearing. So shouldn't your international communications organizations be involved here as well, or reviewing things? What happens if the power goes out? How do you inform the other ships, and how do you inform your headquarters, your flag state, and so on and so forth?
I think
I may be looking at that, I'm not sure, but this is something that's troubled me.
I think different aspects. MASS is such a big development. It involves so many different aspects, and some aspects will definitely involve cooperation with other organizations such as Inmarsat and ITU and ILO and others. But the overall responsibility, the coordinating responsibility, must, in my view, lie with the IMO, because they are sort of the spider in this web.
Okay, I don't think anybody would disagree with that. I guess the question is to what extent there should be, the IMO would have the responsibility to consult other organizations with respect to communications or with respect to labor. Does anybody see an issue with MLC 206?
Well, if I can continue, we can find part of the answer in the Love Sea Convention, which says that we are talking about international competent organization. So if we are talking about matters where there are two competent organizations, yes, they should be involved. When it comes to MLC and ILO, most of the content of MLC is relevant for ships which have seafarers on board and labor on board. There are some provisions like the manning standards, etc., which could be relevant, but they include a significant degree of flexibility as well. But I think yes, it would be good to involve them in the discussion as well. But I don't think it's a sort of showstopper, the MLC convention in this context, because it's a bit sort of outside the whole development.
Okay, I would agree on that. Anybody disagree?
No, but I do have a comment.
Go ahead.
And that is, it's always important to remember that all the conventions that we've talked about are premised upon the fact that there are people physically on board the ships. That's where they came from, because that's all that existed at the time they were created. So we're basically dealing with something which is not anticipated in any of the conventions, and so the discussions relate to how do we take that into account and make the necessary adjustments. I think we shouldn't lose sight of the fact that what we're talking about is something that is really new in the context of the conventions, and how do we deal with it.
Okay. Again, another look at questions. I'd like to look at some of the provisions, particularly Article 94, which we talked about a little bit last week, but I think it's a critically important article. States must, do you see my slides, or I'll have to share again?
Prof, please share the slides again.
Okay. Is that showing the whole slide, or is that?
Yes, yes.
Okay. States shall effectively exercise jurisdiction and control in administrative, technical, and social matters over ships flying their flag. Maintain a registry, but the second part of that is the master, officers, and to the extent appropriate, the crew are fully conversant with and required to observe the applicable international regulations for safety at sea. The assumption being, of course, that there is a master, officers, and crew present. another issue with respect to Article 94, and taking measures called for shall conform to the generally accepted international regulations, procedures, and practices. That is intended to incorporate the IMO regulations. So if the IMO regulations say, though you don't need a crew in certain circumstances for autonomous ships, or you may not need officers, or you may allow a remote control center, then would that be acceptable? Should we read the Law of the Sea Convention provision, therefore, in light of the international regulations that are developed by the IMO, even if they seem to contradict some of the underlying assumptions in the earlier paragraphs in that article? Any comment on that? And there's the casualties, but again, we look at this as one of those convention provisions which incorporates, of course, SOLAS and so on and so forth, right? So if the conventions are amended to deal with MASS, is there any problem raised with respect to Article 94? Yuri.
Well, my main difficulty is, if you talk about interpreting a treaty, I would say, first of all, we need to look at what the language actually tells us. And this is one of my main criticisms. We have a Law of the Sea Convention. If you apply textual interpretation, and if you look at the case law of international court and tribunals, they have placed very much emphasis on textual interpretation. If the result is not absurd or manifestly wrong, then you can look at other considerations as well. But I think particularly with regard to Article 94, there is reference to a master, there's reference to a crew as well. And in my view, the normal understanding of those words would be that those people have a position on board a vessel. And that's why I also mentioned that there are difficulties with the Law of the Sea Convention, because if you look at it from a textual point of view, much does suggest, and I think you also pointed to that, Bob, that the assumption is very much that people are present on board. And therefore, you do have the more general question of to what extent would the IMO be able to adopt regulations which essentially are at variance with that assumption. And I think that is where the crux of the matter especially lies with regards to Article 94, because you do have Article 5, which you just showed, that any measures must be adopted in accordance with the generally accepted international rules and standards. The Law of the Sea Convention does seem to suggest that, or at least its language, that these regulations do presuppose people being on board physically.
Well, unless we'd argue that the master could be the remote control officer, and the crew the crew are his assistants that are the computer specialists that are helping him control the vessel. That is the underlying issue if you're talking about autonomous vessels.
No, I would agree with that. But like I said, if you talk about treaty interpretation, that is not the normal mean to interpret the treaty. So you're essentially relying on more theological interpretations of a treaty, which I think does create some more general issues. I do agree with that people have been quite creative by saying, okay, the master, we're simply talking here about a transference from on board to on shore. But I think that does depart from how you would normally interpret a master on board a vessel. That's at least from the point of treaty interpretation. I do think that many of these interpretations are running into significant difficulties.
Okay, anybody else have a view on 94.4? 94.4 is a big problem. Aldo?
I take perhaps a different approach than yours, although we would start with the same premise. At Absolutely. Treaty interpretation does require particular attention to context and purposes. So in interpreting any particular provision, we should not really independently isolate it from the rest of the instrument, what it is trying to achieve. But in looking at Article 94 and what it is trying to achieve here, is to ensure essentially a system where we have responsibility for ships and that their jurisdictional control exercised over these in accordance with international standards. If we look at the requirement of a ship to be placed in the charge of a master, we can say, look, why can't we interpret in the charge of without necessarily locating it on board a ship? The text suggests that there is flexibility of interpretation, and that interpretation would not necessarily undermine the purposes within Article 94, because the reason we would do this is, of course, to develop international rules and standards to be able to apply to these new technologies. And let's not forget that the Law of the Sea Convention has never really been a static instrument, despite its difficulty to amend. We've seen already some dramatic technological changes that have raised questions as to how particular parts of the convention ought to apply. For instance, marine scientific research. Look, does marine scientific research in the convention directly address satellite-based remote sensing used as research? Well, not really, but yet we have found ways how we apply marine scientific research in a broader way. So I would suggest that the Law of the Sea Convention should really be thought of more as a living constitution of the oceans and interpreted in response to the technological change, which is constant. After all, the uses of the sea are heavily reliant on technology. So as technology changes, we should be expecting that the regimes we have put in place will be under some stress.
You would have no difficulty in the provisions that would say that a remote control operator could serve as a master.
I wouldn't say a revision. I would say the text in Article 94 in the charge of suggests to me we can interpret here in the charge of a person that may be in a shore-based station.
Okay.
If I may, Bob, if I may continue from there, I think we have to emphasize, you have said it already, but we have to emphasize that the paragraph 5 actually makes specific reference to this paragraph and the previous one in saying that in measures called for in paragraphs 3 and 4, and then refers to the IMO rules essentially. But there is another, so this is very important, and this is textual interpretation. I mean, it's not really departing from the text at all. It's highlighting the importance of this particular paragraph. But there is another thing I want to say, which I believe is important. I tried to say it earlier, but it wasn't perhaps very clear. If the IMO would approve an interpretation such as allowing MASS to be operated on a temporary basis or whatever, that you can have temporarily unmanned bridges or whatever. If that were to take place, this of course wouldn't mean that each flag state would have to do that themselves. I mean, they wouldn't be forced to adopting that type of rules themselves. They could continue with their policy with respect to registering ships and putting their standards for their own. This is really it doesn't amount to an obligation to follow IMO rules, because these IMO rules will probably be drafted in the form of an option for those states that wish to approve that form of ships, and flag states are free to ignore that option and stay with their own national ships. And that is another important factor. I think we're not really sort of forcing flag states into anything here, in my view.
Well, I would not sure that I understand you completely, because I would argue that this may give scope for new regulations of the IMO that deal with autonomous levels 3 and 4, that simply say the master's function can be performed by a remote control operator, provided the flag state continues to have jurisdiction, et cetera, but you don't give the code, and then states can agree, or states can have the option, okay, we won't have autonomous vessels, but I would argue if you do have autonomous vessels, then you must comply with the IMO rules that relate to autonomous vessels. Right? The idea is not to give any state the right. The whole idea is to have minimum standards that the state must comply with. That's
Yes.
what the IMO is for.
But they could go beyond those standards.
Oh,
as
they
well
could
if
make it stricter, of course.
Yeah.
Yes.
Yeah.
Then that relates again to how does the flag state, remember the flag state has exclusive jurisdiction over the ship on the high seas. How does it has jurisdiction over the master when he's aboard a ship on the high seas. How does it have jurisdiction over master that is in a remote control center in Manila when the ship is in the high seas? How, again, and then can the flag state simply extend its laws to govern its persons that are operating or controlling its ships, no matter where they may be, whether in their territory or someone else's territory?
We talked about this last week. I think the starting point, of course, is that the obligation of the flag state remained the same. A flag state cannot avoid some of its flag state obligations by sort of contracting out I think that is clear. So if the flag state considers that it's not possible to meet all its obligations as a flag state by having a remote operating center in a different place, then I think it should not permit that. I mean, because if it really, but I think in view of what the world looks like today, and the very weak links between the flag state and the operation of ships more generally, I'm not sure if that is really one should make it very much more stringent for ships that are operated remotely than for ships that are traditionally operated. But in any case, I think it is for the flag states to ensure that all its obligations are met, and then to make agreements between the states where the crew is operated, then to make sure that all its obligations are met. Of course, some of those obligations which are currently carried by flag states, such as social standards or security of the building where the operating center is, that would normally fall under the obligations of the operating state. But I mean, when it comes to navigational and maritime safety, it would still be, in my view, clearly the flag states who would be responsible for all that.
Okay, my only comment would be we don't have a concept of operating state in the Law of the Sea Convention. We have flag states and coastal states and port states. Therefore, it has to fall under the flag state. And that's one of the tricks is how are they going to do that? Shall we move on? Does anybody have other comments, or should we take questions from the Q&A? Yuri.
Well, just one brief point on what Henrik was saying about that currently the link between flag state and ship is quite weak, but I'm just wondering whether we should exacerbate that problem arguably further by saying, okay, with regard to MASS, we're now going to put the obligations on the state where the center is actually based. So I'm just wondering whether or not adding further difficulty to what is already quite difficult to deal with, genuine link. So that's my more general feeling I have with this argument that we're going to further weaken, arguably, the genuine link if it's not properly regulated within the laws and regulations of a flag state.
Well, I don't think you can weaken flag state obligations. You have to have exclusive jurisdiction over the ship, and I would argue anybody in control of the ship.
Yes, but my question would be, how are you going to exercise that with regard to MASS? I mean, that's a thing we're talking about, but I think it is a different dynamic in a way.
Well, a coastal state can, I would argue it could, under general principles of general international law, it could extend its laws to apply to a remote control operator in a second country and bring that person under its legislation, and they would have to comply, as Henrik said last week, maybe in terms of criminal responsibility, you might need a extradition treaty with a state where the remote control operator is present. But it seemed to me the underlying obligation under the law of the sea is flag states, coastal states, and port states. You can't, through regulations, create a new category of different states of states in the location of remote control operators. The flag state ultimately is responsible for controlling the ship flying its flag.
Prof, there is the question about the Professor Chirkov's views on interpretation of Article 94, paragraph 4. What does he view?
I'm sorry, whose question?
The Professor Chirkov's views on the interpretation of Article 94, paragraph 4. What does he
sorry,
view?
I don't have, can you read the question?
Yes, so what does Professor Chirkov's view as the appropriate mechanism to develop such an interpretation?
Professor Cherkov's view.
Yeah.
Aldo. With respect to Professor Cherkov's views on an interpretation of Article 94.4, what does he view as the appropriate mechanism to develop such an interpretation?
Yeah, I can see where it's going, where it's coming from, I can see as well.
Okay, that means you better answer it.
Yeah, no, absolutely. I think this would be one of those instances where I would be comfortable with an opinion from the IMO legal committee as to what in the charge of actually means, and whether it would comprehend a vessel that is remotely operated from a shore-based station. I think this would be one of those instances, which is a technical operational matter. That's how I would look at it.
But do you agree with me that the flag state would have to have responsibility over this, though?
Oh, absolutely. I think what Henrik said is absolutely correct. The flag state is always the front line of responsibility for its ships. It has this fundamental duty of due diligence to exercise effective jurisdiction and control over its ships. And as we know, it's not a duty of result, but it's a duty of conduct. So they have to be exercising jurisdiction and be seen to be exercising jurisdiction. That is not the issue. But of course, that is different from the point raised by the question. The question is more, who should be in the position to interpret whether in the charge of a master would include a shore station.
Okay. Sorry, we Ash, any other further comment on this?
Sorry, everyone. The Captain Roche has some Wi-Fi issues now, so
okay,
he will join us whenever he is able to join us.
Okay, I have one comment here from the floor. The difficulty lies with expertise across ship types and practical knowledge application. The master of an oil tanker will take a different view to the master of a cruise liner. Neither would assume to know the business of the other, and you got a remote control operator has to know the business of every ship, or at least the type of ships that he is controlling. You think you anticipate that as a serious problem, anybody? The real question of what are the requirements of remote control operators? Must they have at-sea experience, and in addition to being computer wizards, etc.? This is, I think, one of the fundamental challenges.
Yeah, Bob, I think the text there in the charge of a master suggests that it's a person who is competent in seamanship, somebody who's been properly trained and so on. So you can't just have a computer expert if we're going to be saying that that vessel is really in the charge of a master. So, of course, this is going to be raising some fundamental questions about the type of personnel needed in a shore office and their qualifications, the standards of training, and so on. Consistent with UNCLOS, there's got to be the equivalence of the training expected of a master
Yes.
Okay, and one of the
maybe-
comments is that in future, your master may not be a human being. We may be some computer running through artificial intelligence. Would you buy that?
I wouldn't, not under our current rules. Under our current rules, we still have to consider that there has to be a person somewhere. So whether it's the person behind the algorithm, whether it's the person at the shore office. So yes, the ship is able to operate remotely. There is somebody in a shore office with competence to be able to operate it remotely. And yes, the vessel will be able to operate autonomously, but the system that has been put in place must have been put in place by persons who are competent to put it in place. And essentially that competence speaks to the kind of training that puts persons at sea to be able to operate safely, to navigate safely, and to ensure the safety of others. I would say that those criteria would still apply to any vessel that is out at sea.
Okay, I'm going to paraphrase a couple of questions or combine them. If you're talking here about the flag state, issues are raised as to the so-called flags of convenience or open registry countries, and the issue of genuine link. When it comes to mass vessels, are we talking about a real genuine link is required between the flag state and the control of the vessel? Or is it business as usual? Anybody want to tackle that one?
You know, I argued last time at our first webinar that if I were advising a flex state, and as Henrik rightly pointed out, the flex state can impose its own standards. But it has to take into consideration, of course, that it has to comply with international conventions and so on. But one thing that it could do to ensure it is in a position to exercise effective jurisdiction and control is to require that that the shore office for remote operations is actually located in the flex state. That would be my conservative view, to enable the flex state to exercise its due diligence obligation. In other words, to place itself in a position to be able to exercise effective jurisdiction and control.
Okay, then it would be up to STW and whatever to have qualifications and training and experience for the remote control operators, assuming they're located in the jurisdiction of the flag state.
And I think until we have proper MASS specific standards for that purpose, we should apply the normal ones, because as the previous question also highlighted, it's important to know the characteristics of the particular ship. But even more importantly, at least in the beginning, is of course to know how the other ships around will sort of reason and to understand. You need to be a qualified seafarer to be able to operate a ship, because you need to know how the other ships will respond as well. It's a different, I mean, if we are then gradually moving towards a situation where a large majority of the ships will be mass, then of course the seafaring skills might become eventually less important than the computing skills more important. But in these early phases, it's very, very important indeed, I think, to make sure that you not only understand the own ship, but also how other ships behave in the vicinity.
Okay, let me move to another question, which I think, I mean, there are lots of questions relating to the issue of flags of convenience and jurisdiction, et cetera. And I think it's something that IMO is going to have to think about. Here's one: as flag state jurisdiction has proven in practice to have many shortcomings and challenges, particularly for flags of convenience or open registry flags. With the advent of MASS, should international rulemaking explore a new paradigm to allow more jurisdiction to affected coastal and port states, and place more responsibilities on states that allow remote control centers to operate in their jurisdiction? Any comments on that one? Aldo, is that consistent or inconsistent with yours? You say it still should be flag states.
if we operate within the current regime and we're trying to make the current regime work, as it were, rather than develop new law, I would say my approach would help us move in that direction, because we know how difficult it is to develop new international instruments. The extent to which one should perhaps give greater authority to coastal states, well, the coastal states already have a very, very significant expanded authority as a result of UNCLOS. So I'm not sure what additional authority they would need. It seems to me what we have to consider rather is the realistic scenario of having a host state for a shore office, which is not the flag state, and which is not, let's say, the coastal state, if there is injury caused to a coastal state. And
okay.
That is the question we have to deal with. How do we deal with that situation?
Again, I'm not sure I agree with you on the extensive powers of coastal states. One, if I were a coastal state and their mass vessels are starting, I would want to have mandatory ship reporting when that vessel comes near my coast. Because if something goes wrong, I want to know how to communicate with it.
Yeah,
and now then the issue is how does the coastal state authority communicate with a mass vessel off its coast?
Look, regulation has to apply here. And what that coastal state will have to do is to request a reporting measure from the IMO under Chapter 5 of SOLAS of all mass vessels. So basically, the technology would have to be configured so that it can interact with the coastal state to be able to comply with the reporting measure.
I think that's, to my view, I've been thinking about that. I think that's critically important, that the mass vessel is able to communicate with the coastal states that it is in whose waters it's passing or close to them, and to any port state that it is going to come into. But what happens when communication breaks down? What is your backup? What if you, I mean, how do you communicate with a vessel? If a passing ship cannot communicate with a vessel, it's in the wrong lane in a traffic separation scheme, how does it communicate with a mass vessel?
But Bob, that is potentially a problem with any other ship, and that is why we have the collision avoidance regulations and the system signs and shapes and lights at night. So if you have, for instance, a vessel that has a real problem with its ability to navigate, to maneuver safely, it will hoist the not under command signs and has those lights at night. And those are readily visible and understandable under COLREC. So mariners are trained to recognize those signs and those lights and stay out of the way of that vessel.
But who is controlling, who's putting up the signal?
Well, we're assuming here that MASS is still ultimately subject to some human oversight. So I can't imagine a technology even based on full autonomy that ultimately does not have some human oversight. There's got to be some oversight somewhere. Otherwise, we have a fundamental issue with who is ultimately responsible at law.
But again, it assumes that human oversight, that the communications are not going to break.
But all this is, of course, things that it will be very difficult to resolve at this stage. But I think these are typical things that the IMO needs to consider. It's really about redundancy. What type of measures should be there completely independent of each other to provide a reasonable level of safety and for this kind of ships? And this is really need to be subject to very, very careful deliberations. But also there have to be probably rules on some sort of fail-safe modes. I mean, when all communications breaks down, the ship somehow turns from level 3 to level 4, and it needs to have some autonomous skills or to behave in a certain manner. All this, there should be rules for all this. It's not that we sort of, the process is that we sort of accept MASS and then a jungle breaks. So these things need to be be addressed, and it will take time. But I think nobody is interested in having a kind of agreement to allow MASS without having this type of safety standards in place.
Yeah, I just put up 94.7. I'm not sure you can see that, but again, the need for following a maritime casualty or incident in navigation, need for an inquiry. Again, that is, it furthers, I think, Aldo's point that the flag state ultimately is the one that should be accountable and responsible, and they're the one that's going to have to cooperate on any inquiry. And it'd be very dangerous to put states where remote control operators are present into the equation, because the provisions are dealing with flag states. Ultimately, it's their responsibility. Does anybody, there's another question that's come up again, duty to render assistance. I think the IMO must have looked at this with respect to SOLAS, but people see that there's any difficulty in this article?
Bob, can I?
Sure. You want to come back to the other one, or you want to do this one?
Yeah, no, I briefly want to come back to the other one as well about the possible. I was just thinking about the question and the mention made of, should coastal states not have more powers with relation to MASS? But I was also thinking that ties in with the discussion of Article 91, in the sense that if a flag state designates a MASS as a vessel, does the coastal state have an obligation to accept that designation? I think that's also a very relevant question. And I think generally the answer would be that coastal states have to fall in line, essentially. If a flag state gives vessel status, it would be an actual vessel. But I think in practice, it might well be that coastal states take a position at variance with that. And then the question would indeed be, what then? Could they then act if it would be in a territorial sea? So in my view, that question can't be really separated from Article 91 as well.
Okay, if we could, I think I put up 91. Yeah, 91, of course, there's no definition of ship. The UNCLOS uses ship and vessel interchangeably, depending on which committee the provisions came out of. And neither ship nor vessel is in, there's no definition in UNCLOS on what a ship or a vessel is. And there's different interpretations of what Article 91 means. Some people say that it state has the right to declare anything a vessel or a ship in their nationality, and other states must accept it. But Yuri, I think you would argue that some states might say, well, we don't accept that this is a ship.
No, because in my view, there has to be
ship must have a master and crew. Now what?
Yes, and I think you can make that argument, because I think there's still a minimum threshold implied in Article 91 that a coastal state does not need to accept every single designation, because I think the literature mention has been made, if that vessel is able to comply with the current international laws and regulations, then it would have to be accepted by the coastal state as being a ship. So currently I would say there's clear ground on which a coastal state could act. If the IMO would take up the issue, then it would arguably become more difficult. But I still believe, because we have these discussions, and it's quite clear you can have different views on how to interpret the Law of the Sea Convention, and these may be well mirrored in state practice as well. Probably it's too early to tell, but I think there might be risks involved, where you have some states who simply don't accept MASS as being vessels if they go through their territorial sea. Like, it's a more theoretical discussion, but I think you can't really exclude that possibility, especially in light of, we have been now discussing the issue quite extensively, that you can, in my view, justify different interpretation based on the text of the Law of the Sea Convention. And what if a coastal state in its own legislation does indeed have the requirement of a ship having to be manned by a crew and a master? Of course, it might be that state practice develops in a particular direction, but as mentioned, it's probably too early to tell. But I think there is the possibility of problems being created in that regard, as long as you don't address the issues that are present in the Law of the Sea Convention.
Yeah, I think Yuri makes a valid point here. I would argue that it is a transitional concern until we have new MASS-specific gyras coming out of the IMO. Then there would perhaps be less of a concern for a coastal state on whether it recognizes a particular vessel as a ship or not.
Okay, I agree on this. I think definition of ship is going to rise in more cases with respect to not merchant ships, but either state vessels or research vessels that are unmanned and they're underwater, and the coastal states are concerned about their security being jeopardized, and they might not recognize them as ships. That's a slightly different issue that gets into the maritime security. We have another question coming up. In the case of a complete breakdown of a ship and absence of shoreside control, in such a case, who's the master, human or otherwise? Maybe we'll cross that bridge when the time comes, but what are your thoughts? Anybody?
Well, first of all, I don't think it's a very likely scenario, sort of on a regular basis to have MASS even in the midterm future that would be operated without any type of human involved. So that without any type of human intervention for periods, yes, but I think if one, I mean, a very elegant way of meeting this type of concerns would be to say that there would have to be a person responding to calls by on VHF, or etc., relayed from the ship to the shore base, and at least at that point, or when an alarm goes, there would be a person coming in. But there was you started off with a complete breakdown when everything sort of breaks down and there is no communication link at all. That, of course, is a very, very awkward situation, and it's an awkward situation for any ship when there is a blackout and nothing works. But in respect of MASS, I would say that there would have to be some sort of fail-safe procedures in place in that what that ship is then programmed to do, whether it's about keeping its place or anchored. It would of course depend on what the situation and the context, and but some sort of standards for what would happen in those situations and what lights it would show, etc., etc. But this is, of course, is an extreme case, and the regulation has to sort of be directed at avoiding such an event from happening in the first place, as it is in the current regulation on maritime safety.
I do not see this as necessarily a problem. I see it rather as an issue for salvage. The vessel will obviously become a potential subject for salvage. The question, living where I am, would be whether it would be contract or common law salvage, depending on whether there's communication with the shore office.
Okay, maybe you can do, we're running out of time, but maybe you could take one other issue, and those are the provisions relating to vessels in distress or persons in distress. Kind of how does the MASS vessel deal with fishing boat that has people that are about to sink? It's an obligation on states to require their masters to rescue. How do you deal with this with a MASS vessel? Anybody have thoughts on that one?
Maybe I could start. I don't know. I think, yeah, this is an obligation in the Law of the Sea Convention, Article 98, I believe, but it's also an obligation in SOLAS Chapter 533, and even in the old Collision Liability Convention from 1910, there is a provision to this effect. I mean, it's an old principle that the master shall take measures to help people in distress, of course, but I think it's very important to bear in mind that these obligations on the masters are not absolute obligations. They are obligations which are qualified by provisions such as all things that can reasonably taken without endangering the safety of the ship itself, etc. So clearly, if a MASS is confronting this situation, the obligation would apply, but the range of measures that the MASS can take is obviously more limited than a fully crewed ship. The obligation to help would still be there. It could be assistance in the form of relaying radio traffic, acting as a or maybe even lowering the vessel if that is feasible to take people on board or whatever. But I think they are not absolute obligation, and this is very important to bear in mind. The other thing which is important to bear in mind, that this is really a provision which deals with exceptions. I suppose it would be really like the tail wagging the dog if a provision like this, which really is a very, very special event, and I suppose it happens very rarely that the master is in this. If that sort of extraordinary event would be taken as a instrument for preventing the development of MASS in the first place. So I think it has to be in perspective.
Okay, I agree with you on that. Probably doesn't have much food on board either if it doesn't have a crew. So, okay. Anybody else want to make any closing comments? I think we've come to the end, particularly on the issue. What advice would you give our friends at the IMO if they're thinking about considering the issue of examining your UNCLOS together when they do their scoping exercise? Would you recommend they do so? And do we see a light at the end of the tunnel?
Oh, yeah,
2025. Aldo?
Yeah, there is lots of light. If that is, yeah, sure. There is some uncertainty because the technology just forces us to rethink so many different applications. But it seems to me that the IMO Convention itself has equipped the organization with the necessary authority to carry out this interpretative exercise. And the convention itself, the IMO Convention, the 48th Convention, also has mechanisms internally when there are difficult issues of interpretation. So difficult issues of interpretation, if the legal committee, for instance, is deadlocked or whatever, it can always refer the matter to the assembly. The assembly has indeed the authority under Article 69 of the convention to advise on the course of action and to settle the matter. But if it turns out that there is a legal question which is so difficult to address that the organization itself perhaps cannot address it, well, the IMO Convention has Article 70, which says, look, an advisory opinion from the International Court of Justice should be sought. And this is consistent with the UN Charter. Article 96 of the UN Charter is very clear that if there are questions of requiring legal interpretation for any of the specialized agencies of the United Nations, then the International Court of Justice would be an appropriate venue for an advisory opinion. So there's a system. Legal committee is in the front line. If there are difficulties there's the assembly. If there are further difficulties, advisory opinion through the International Court of Justice.
Any, Ash, you're away for a moment, for a few minutes. Any closing thoughts?
I was away for more than a few minutes. It's been about an hour since I was able to reconnect. So I'm listening to what happened while I was gone, but I'm pleased that I at least could hear what you said.
Okay. Henrik, closing thoughts?
I think yes. What Aldo says here is interesting. But generally speaking, I think that IMO should concentrate now on asking them itself whether these ships, whether the maritime community wants this type of ships, and to start considering in what ways to make them as safe as possible and at least as safe as existing ships and do its normal work, not to bother at this stage too much about the impact of the law of the sea convention. I think in particular, if we are talking about this flag state link, that is obvious. But I agree with Aldo what he said earlier, that when it comes then to more coastal state jurisdiction matter, then we are moving from a kind of a typical flag state GIRAS IMO perspective more to questions of what rights coastal states might have in putting their own limitations on the passage of this kind of ships. And ports that, of course, do have very broad rights, but to what extent do, for example, coastal states in the territorial sea? This would be a more typical law of the sea question, and that would, when moving into that direction, maybe those kind of questions should be triggered. But I think for the moment, the main focus should be on developing rules that make them safe and consider that UNCLOS is not a main impediment for this purpose.
Yuri, closing thoughts.
Yes, well, I would argue that they should actually look at the law of the sea convention, because to me it seems that if you don't do that, you're putting the cart behind the horse effectively, or before the horse, sorry, the other way around. So therefore I would very much applaud that they do look at the law of the sea convention and to what extent, or critically look at to what extent they are indeed able to address the issues that they want to address. Because if you wait, I'm not sure whether the law of the sea convention itself may not be an impediment to these becoming a commercial reality. I understand it's very much driven by this ambition within the maritime industry to have MASS, but I think it's better to regulate them properly, and particularly on the international level, because I think if you do it the other way around, that if you treat the law of the sea convention more as an afterthought, that is putting the cart, as mentioned, not behind the horse, but actually before the horse. So that would be more my view on that they do need to look at the law of the sea and whether it presents any difficulties. And I particularly like Aldo's suggestion, which you mentioned about the advisory opinion. I haven't come across this one yet, so I would suggest they could seriously consider that as well.
Okay, my own closing thoughts. I guess I agree with Aldo in terms of the, we should look at, I think the committee or the joint committee, however IMO approaches the issue, should examine UNCLOS. I don't see any, in my view, obstacles that are going to prevent anything, and I would hope that they don't see any issues that they would have to seek the advice of the International Court of Justice on. I would hope that the shipping law experts at the IMO, consulting with law of the sea experts, can resolve these issues rather than turn it over to a court that is generalist on general international law, not either perhaps shipping law or law of the sea, with a couple of exceptions. My own view is that the IMO has the sufficient expertise and the years of experience to deal with it, and they shouldn't hesitate in looking at the implications of the law of the sea. That's my own view.
Remember, Bob, there is a precedent already.
I know there's a precedent, but it's quite old, and I'm not sure that I would follow it at this stage. I agree with you, there's a precedent, but that doesn't mean we keep it there as a precedent. Don't try to follow it. Ash, any closing thoughts? You want to go to the assembly. You think they should go to the assembly first. That's the...
Yes, indeed. And I suspect that the assembly is going to address this issue in any event in coming days. So we'll see. To be determined, as they say.
Okay, with that, I'd like to thank very much our 4 panel members, our technical staff, and the audience for very good questions. Our apologies if we missed some of your questions. We tried to, in some cases, summarize a couple of questions into one point. Thank you very much.